I'd like to welcome everyone to the Pennsylvania Human Relations Commission's Fair Housing and Power program. Today we're going to be talking about fair housing and criminal backgrounds. My name is Brittany Mellinger. I am the Fair Housing Training and Outreach Coordinator at the PHRC, and I'll be your trainer for today. So I want to do a couple quick housekeeping items while we get started. First, I'd like to invite you to feel free to introduce yourself in the chat. Thank you to everyone who's done so already. I want to let you know that our program is being recorded today, and we will be sending out the recording at the end of the presentation along with materials. So you'll receive that within the next few days. I'd like to thank our interpreters as well as our captioner for making this program accessible today. So if you would like to access the captions, I'd like to invite you to go to the top of your screen where there's 3 dots. For more actions, then you can go to language and speech and go to the turn on live captions option. And that should pull up captions for you. If you have any questions or run into any issues, please feel free to drop a message in the chat and we'll help to resolve that for you. I'd like to thank PHRC's Director of Fair Housing and Commercial Property, Caroline Eister, for providing technical assistance for our program here today. But let's get started. I first want to introduce myself. My name is Brittany Mellinger. I'm the Fair Housing Training and Outreach Coordinator. And we're going to go through the content at this point. So we always start by talking about how fair housing is the right of all Pennsylvanians. This is so central. Where you live really matters. So it's important to make sure that all Pennsylvanians are able to access quality, fair housing that meets their needs. And that's why we put such a strong focus on putting fair housing education and information out to the community. So that way folks are fully aware of both their rights as well as their responsibilities in the housing process. We've got a couple goals for today's program. We only have an hour, but we are hoping to do a few things together. I'm going to start by providing a brief overview of our agency. We're going to talk about fair housing laws. We'll discuss protected classes and discriminatory practices, just laying a groundwork for fair housing knowledge. So that way we can get into a little bit more detail around our topic for discussion today, looking at discrimination against individuals who have criminal backgrounds, how housing providers can navigate those screenings, as well as how prospective tenants and those who are working with them can understand their rights. We're going to talk about the complaint process, and then we're going to answer your questions. So I invite folks to enter questions in the chat throughout the program. As things arise, please feel free to put any comments that you'd like in there as well. I'll keep an eye on it, but anything that we can't get to throughout the course of the program, we'll leave some time towards the end to make sure that we can answer those questions for you. But first, I want to let you know who we are as an agency. So the Pennsylvania Human Relations Commission has been around since 1955. We're the state's leading civil rights enforcement agency, and we work to make sure that Pennsylvanians can live, work, and learn free from unlawful discrimination. So our mission has 2 parts. We both enforce Pennsylvania's non-discrimination laws, which include both the Pennsylvania Human Relations Act, as well as the Pennsylvania Educational Opportunities Act. And that means that when folks have a complaint, they're welcome to file with us to have a neutral investigator take a look into the situation and see if it was a violation of our state law. But beyond just reacting to complaints as they come in, we also work to actively promote equal opportunity for all in Pennsylvania. And we do that through trainings such as this one, through events, through forums. We also have community groups and volunteers that work to support our mission as well through our advisory councils and our social justice ambassador program. If you have any interest in getting further involved in our work, I would love to share with you more information about how to do so, and you can email me after the program. We serve the entire state of Pennsylvania through 3 different regions. So our western region is in the dark blue there, and that's served by our Pittsburgh regional office. In the central part of the state up into the northeast, that's our central region, and that's supported by our Harrisburg regional office. And then in the southeastern corner of the state in that medium blue, that is served by our Philadelphia regional office. These are the offices that take complaints, that do investigations, and do a lot of the daily work of the commission. But we also have a central office team that does a lot of the outreach and administrative functions as well. I briefly mentioned our laws that we enforce, but I wanted to share some information with you about what they actually cover. So the Human Relations Act covers employment, it covers housing, it covers commercial property, public accommodations such as public businesses and services, as well as primary and secondary education up through high school. The Pennsylvania Fair Educational Opportunities Act covers post-secondary education, such as college, trade schools, technical schools, things like that. But we're going to move on to focus on the fair housing space, since that is why we are here today. I want to start off by covering the goals of fair housing. So goal number 1 gets a lot of attention: ending housing discrimination, making sure that no one is kept out of housing opportunities because of acts of discrimination and discriminatory policies. But goal number 2 is equally important, and that's promoting diverse, inclusive communities. In the fair housing world, we call that affirmatively furthering fair housing, and that's defined as taking meaningful actions in addition to combating discrimination that overcome patterns of segregation and foster inclusive communities free from barriers that restrict access to opportunity based on protected characteristics. So it acknowledges that our country has had a problematic housing past. A lot of our practices, a lot of our laws have limited housing opportunities for individuals and created patterns that have ensured that not everyone has equal access. And those exist today, even though we've had fair housing laws for decades. So there's more work that needs to be done to make sure that all of our communities have opportunities and that everyone's able to access the community that they would like to be able to live in. But what do our fair housing laws cover? They cover the sale and the rental of housing, as well as housing-related transactions. So when I talk about housing-related transactions, that refers to the wide range of businesses and industries that support the housing industry, that help to make these housing transactions happen. So that could be our lenders, that could be our appraisers, that could be our insurance agents, folks that have an impact and can be a huge player in making sure that everyone has equal housing opportunities, even if they aren't the folks that are signing the lease or turning over the keys to a home buyer. There's a lot of people that are involved in making housing choices and housing decisions. The types of housing that are covered by our fair housing laws are broad as well. So that's anything from apartments to single-family homes to manufactured home communities, condominiums, public housing, nursing homes, student dormitories, and more. Even some types of shelters are covered under our fair housing laws. And I want to cover 2 separate discrimination theories or types of discrimination. So the first one, disparate treatment, is one that we often think about when we picture an example of housing discrimination. So that's treatment that directly discriminates against a member of a protected class. So for example, looking at the protected class of disability. So if a person with a disability would go to rent a home and would be told by the landlord, look, I'm really sorry, I don't think this place is safe for you to live here because of your disability, so I can't rent this place to you. They're being treated differently and being denied housing opportunities directly because of their protected class, because of their disability. Disparate impact can be a little bit more insidious, a little less obvious. So it's defined as a policy that's neutral on its face, but it has a disproportionate or a disparate impact against a member of a protected class. So looking again at individuals with disabilities, say a housing provider would have a policy for their rental housing that everyone to qualify for that housing must have full-time employment. Now, when we look at statistics of employment of people who have disabilities versus those who don't, folks who have a disability have lower rates of employment. So this policy would have a disproportionate impact on keeping individuals with disabilities out of these housing opportunities because of this policy. All right, I see a hand raised. Esther, would you be able to put your question in the chat and we'll get to it as we're able? All right, let's look at our fair housing laws. There are different layers of fair housing laws at the federal, at the state, and at the local level. So at the federal level, there's the Fair Housing Act of 1968, the FHA for short. There's Section 504 of the Rehabilitation Act of 1973, as well as the Americans with Disabilities Act of 1990, known as the ADA. So these provide protections at the federal level across the entire country. At the state level, it's the Pennsylvania Human Relations Act, the PHRA, that provides the basis for our fair housing protections. And then there are over 70 different local ordinances throughout Pennsylvania that provide additional protections for individuals in protected classes. So I'm curious to know if anyone is joining us from an area that has a local ordinance, if you would want to put that in the chat, share what your locality is or what that ordinance is. I'm always curious to see how many folks are aware of these additional protections that might be available in your town or at your county level or in your city. And I want to touch on housing jurisdiction really briefly because it looks a little bit different under our federal and our state laws. So who's covered as a covered housing provider? Who has a responsibility to be able to abide by our fair housing laws? Under the Fair Housing Act, that's housing providers with 4 or more properties, unless they're publicly advertising their vacancies or receiving federal funding. If they do publicly advertise or if they do receive funding from the federal government to support their housing, then they do need to comply regardless of how many properties they have. Under the Human Relations Act, it's much more simple. So it's housing providers with 1 or more properties. And then the filing timeline can look a little bit different as well. So under the Fair Housing Act, a complaint must be filed within 365 days, 1 year from the date of the last harm. At the state level, if someone wanted to file with our agency, they would need to file within 180 days, about 6 months from the date of the last harm, for us to be able to investigate that complaint. I see the question about the credit check, and I will address that at the end of the presentation. Thank you so much for raising that. All right. Their protected classes can look a little bit different at the federal and the state level as well. So under the Fair Housing Act, there's 7 protected classes. So there's the race, color, national origin, familial status, religion, sex, and disability. It's expanded under the Pennsylvania Human Relations Act. So we still have race, color, national origin, familial status, religious creed, sex, and disability. But we also add on age 40 and above, ancestry, as well as the use, handling, or training of support animals for disability. I want to go into a little bit more detail about a couple of these protected classes. So familial status is defined as families with children under the age of 18 who are living with their parents or legal custodians. It also includes people who are pregnant, as well as people who are securing custody of children under the age of 18. And that includes foster children as well, not just biological children. The protected class of sex is broad as well. So you didn't see LGBTQ, sexual orientation, gender identity as separate protected classes, either at the federal or the state level, but we do have protections for individuals that fall under those categories. So last August, we finalized regulations that define the protected class of sex. And it's defined as referring to pregnancy status, childbirth status, breastfeeding status, sex assigned at birth, gender identity or expression, affectional or sexual orientation, as well as differences in sex development. So individuals can file a complaint if they believe that they've experienced discriminatory treatment based on their sexual orientation, their gender identity, any of these categories. They can file that under the protected class of sex and have that situation investigated, even though we don't have those as separate protected classes. And we use these regulations as we accept complaints, conduct investigations, and adjudicate cases. And we do have more information about that on our website if you're interested, and that link is on that slide. We'll receive all of these slides as well as the recording within the next few days. And then the last protected class that I want to cover in more detail is disability. So the definition of disability is a physical or mental impairment that substantially limits one or more of a person's major life activities. Some examples of this include caring for oneself, walking, seeing, hearing, speaking, breathing, learning, or working. It's not exhaustive, but those are some examples. And I think it's important to note that sometimes someone's disability may be immediately observable, but a lot of times it's not observable. And someone might need to disclose it in order to get the accommodation that they need to use and enjoy their housing. But regardless, observable and non-observable disabilities are equally covered under our fair housing laws. And our fair housing laws protect those who have a disability, those who have a history of a disability, as well as those who are regarded as having a disability. There are a few exemptions. So individuals who are currently using illegal drugs are exempted from disability-related protections. So if they're currently using controlled substances, they would not qualify for fair housing protections as someone with a disability. But if someone is in active recovery, then they would have that protection. If an individual would pose a direct threat to the health and safety of others, they would also be exempt to disability-related protection. But that should be something that can be substantiated, not just based on stigma or assumptions. I do see there's a question about the disability-related example that I provided earlier, and that question is, if the person's disability creates a safety issue and the landlord wishes not to rent, are they discriminatory? So a renter who's confined to a wheelchair and the only bathroom is on the second floor. In that case, the landlord should open up a discussion with that person with a disability rather than simply denying them. So that's called engaging in the interactive process. That way, the person with the disability can share if there's an accommodation or a modification that they would need in order to use and enjoy the property. But that way, it's the individual with the disability that can make that call, not the landlord, because the individual with the disability knows their needs and their limitations and what they need in their housing better than the landlord does. So it's always better to open up that conversation and to have it in a respectful manner. So that way the prospective tenants can make that call rather than having the landlord make that call. All right, we are going to discuss discriminatory actions really briefly, and we've got a much more extensive presentation that covers this in more detail. But here's a list of some actions that, if it's taken on the basis of someone's protected class, would be discriminatory. So, such as discriminatory statements in terms of advertising or promoting a unit. Discriminatory inquiries about someone's protected class as they are seeking to rent a unit or buy a home, steering someone to a certain neighborhood, to a certain type of unit, to a certain floor based on their protected class, not giving them the option of choosing for themselves. Refusing to sell, lease, or finance housing, that's relatively straightforward, right? Doing an unfair appraisal on the basis of protected class. Predatory lending in terms of offering poor terms and conditions, of redlining based on the demographics of a neighborhood, discriminatory treatment in the terms and conditions of a lease or the sale of a home or financing of the home, such as the terms that are in the lease or the property agreement. Unlegally providing services and facilities in terms of where someone can access, which areas of the property someone could access, or the types of services that they can receive at the unit, the speediness and quality of maintenance repairs, things like that. If that's on the basis of protected class, that would be discriminatory. All right. I think I was temporarily knocked off of the call, but thank you for your patience. Was and to be home. Receive threats and intimidation on the basis and the accommodation. For an applicant. Hi, everyone. I do see the comments in the chat that there were some issues in hearing me. Is this any better? Is it okay? I see a yes. All right, wonderful. We are back online. Thank you all for your patience. I apologize for the technical issues. All right, wonderful. I'm seeing lots of yeses in the chat, which is great. I believe before all of the technical issues, we were on the topic of harassment, and I just want to state that individuals have the right to a home that is safe from harassment, where they feel safe and welcome and not attacked, intimidated, threatened on the basis of their identity and their protected class. It is discriminatory for a housing provider to refuse to provide reasonable accommodations and modifications for individuals with disabilities. So reasonable accommodations is a change in policy, and a modification is a change in structure. So using our discussion from earlier, the bathroom on the second floor, if someone would need a chairlift in order to be able to get up to that second floor to use the restroom. There's a question in the chat about, does the landlord need to pay for that, or is it the tenant's responsibility? If the housing provider receives federal funding, then it's the housing provider's responsibility to pay for that change to the structure. If it's a private landlord who does not receive funding from the federal government, then it's their then it's the tenant's responsibility to be able to make this change and pay for it. And they may be required to restore that back at the end of their tenancy. We've got a whole training on reasonable accommodations and modifications if anyone is interested in learning more details about that. But I want to go on to our subject matter of today, looking at criminal backgrounds. So just to give you some background statistics to frame out our conversation a little bit, I want to share that approximately 1/3 of American adults have some type of records. So that's 70 million Americans. This isn't an isolated issue to just a few folks. This impacts so many people's access to housing. And we know that a stable home is critical for individuals who are returning from incarceration. And we know that it can be really difficult to get stable housing after that. So 30 to 50% of individuals on parole don't have a stable home. And individuals without affordable, stable housing are more likely to recidivate or to recommit a crime and go back to prison. Now, in a 2017 study, it found that 90% of landlords do look at criminal records when they're considering potential tenants. And in that survey, they ranked it as number 3 in importance behind income and event history. So we know that this is something that housing providers look at when they're considering whether someone's going to be a good tenant or not. In a separate survey of folks who are reentering from incarceration, they found 79% of respondents reported being ineligible for or denied housing because of their records. 1 in 10 reported that family members had been evicted when loved ones returned from incarceration. So this is something that is a housing barrier, and it can also destabilize housing. There's a 2019 study that found that most types of criminal backgrounds actually don't increase negative housing outcomes, such as failure to pay rent and eviction as a result. And after time, a criminal background actually becomes insignificant in housing outcomes. So for a misdemeanor offense, it's within 2 years. After 2 years, it makes no difference. And for a felony, it's after 5 years. So that's something to keep in mind for the housing providers on the call when you're considering how to create your screening policies. It's important to look at the data to see how long there's actually an impact, and to make sure that your policies are reflecting current data on that. Now, some folks are like, well, why is criminal background even a fair housing issue? Because clearly it's not its own protected class. We went through all of the protected classes at the state and the federal level. Criminal history didn't appear on there. But there can be issues and violations of fair housing laws in the ways that people's criminal history is used to deny housing. And we're going to talk about 3 separate things. So we're going to talk about disparate treatment, disparate impact, as well as refusal to make reasonable accommodations. And we defined all of those earlier in the presentation. So think back to that. We're going to start by disparate treatment. All right, so a housing provider may not intentionally discriminate based on a protected class in the ways that they use criminal history and screening. So some examples of using criminal backgrounds in disparate treatment include a housing provider who's running background checks on Black applicants, but not on white applicants. So they're using this tool as a way to exclude applicants based on race, as well as a housing provider that discourages rental applicants from Hispanic potential tenants with a record, but would encourage non-Hispanic applicants with a similar record to apply. So looking at someone's national origin or ethnicity, and using criminal background as a way to screen out. That would also be an example of disparate treatment. I do see there's a comment in the chat that slides are not advancing, and I apologize for any technical difficulties, and you should be able to advance them on your own to be able to keep current if it's not automatically happening. Again, I apologize about that. All right, for disparate impact, again, that's a policy that has a discriminatory impact even if it appears to be neutral. An example of that would be a blanket ban policy. So a blanket ban is denying everybody with a criminal record, regardless of how relevant that record is, how severe the offense is, how long ago it happened. Just saying anyone with any kind of a background, they're not welcome to apply here. That's going to have a disparate impact because of the ways that it limits housing opportunities for people of color. We're going to get into that in a little bit more. So this is a disparate impact because of the ways that people of color are overrepresented in our criminal justice system. So there's some stats here that you can take a look at. Black individuals are 7.4 times more likely to be incarcerated than white individuals in Pennsylvania, and Latino individuals are 2.4 times more likely to be incarcerated than white individuals. Looking at it within the framework of the entire United States, Black individuals are 4.8 times more likely to be incarcerated than white individuals, and Latino individuals are 1.3 times more likely to be incarcerated than white individuals. And this data was sourced from the Sentencing Project. But I think it's important to note that while people of color are overrepresented in the criminal justice system, it's not that they're committing more crimes. It's because of disparities in the ways that communities are policed, sentenced, and supervised. So according to the Reducing Racial Inequality in Crime and Justice report, Black individuals are more likely to be stopped by police. They're more likely to experience use of force by police, and Black officers treat police officers treat Black people with less respect than other races. Black criminal defendants are more likely to be detained pre-trial and convicted as a result. So all of this comes into play in looking at who may have that background and who might be excluded from housing. And again, a policy that excludes all applicants with a criminal record may have a disparate impact on Black and Latino applicants. All right. So to prevent this disparate impact, to make sure that we're not having policies that are having unintended consequences in limiting our housing access by race, housing providers should use a screening framework that does allow for individualized assessment. So this assessment should look at the recency of the offense, the severity of the offense, as well as mitigating circumstances for the offense. And the housing provider should communicate this process and factors for assessment very clearly in writing to prospective tenants. That way there's no questions about how they're considering applicants, what the process is, it's upfront, and everyone has an equal understanding of that. I do see there's an additional comment about slides not advancing, and I apologize. There should be arrows underneath the slides that allow you to advance slides independently, although it should be they should be advancing on their own, and I'm not sure why they are not. Thank you all for hanging with us in terms of our technical difficulties. So I want to go on to reasonable accommodations and how that can impact housing opportunities for individuals with disabilities who have criminal backgrounds. So individuals with a disability do have a right to request a reasonable accommodation that's needed for them to use and enjoy their housing. And as a reminder, a reasonable accommodation is defined as a change in rule, policy, practice, or service that's necessary for an individual with a disability to use and enjoy their housing. So when a housing provider is considering whether they should grant a reasonable accommodation for a prospective tenant, they need to establish some criteria. So first, do they have a disability? Do they qualify under the Fair Housing Protections as having as an individual with a disability? And is there a disability-related need for this accommodation? So is there that connection with that request? Is this on the basis of their disability, and will this actually enable them to use and enjoy their housing? And is it something that's reasonable? Is it achievable? All right. So what could this look like in a setting looking at criminal history? So potential reasonable accommodations that might be needed could include waiving or altering a criminal record screening policy. It could include disregarding aspects of an individual's criminal history when determining their acceptance into housing. It can include changing how much consideration is given to an individual's criminal history, and it can include considering mitigating circumstances. So looking at the example on the screen here, a tenant with a history of substance abuse has some minor offenses on their record that are related to that substance abuse. But this tenant has been sober for 5 years. So I'd like to invite you all to be able to answer that in the chat. Do you think this reasonable accommodation, should this be granted? What do you think? Is this something that's reasonable? Is it connected to their disability? And does this person qualify for fair housing protections? I see one person has said yes. I see a question of, hey, can we verify that? Another yes. So that's a good question about verification. Can we know that that's true? There might be some supported documentation that's needed. So obviously there's going to be information about the offenses that they committed, what's on their record, but they could provide some information about their treatment, their consistency on that, some information from a provider that would establish that. That could be some supporting documentation that a tenant could provide as they're making that request. And Gloria, the interactive process should begin. Absolutely. It's part of that conversation to see how this person's disability-related housing needs can be met in a reasonable, effective manner. Absolutely. Great discussion. I appreciate that. All right, there are a couple exceptions when a reasonable accommodation would not be appropriate. So there's some federally funded housing that has prohibitions on certain offenses. So one is under lifetime sex offender registration. And there was a question in the chat earlier about someone, I'm looking back here, but there was a question about someone who is registered. And if there's a lifetime sex offender registration, some federally funded housing will not make an accommodation on that basis. Or if someone has a conviction of manufacturing or producing methamphetamine on federally assisted housing. And for these types of housing, these offenses may not be waived through a reasonable accommodation. Of course, a private housing provider may make their own decisions on this, but for federal programs, there are restrictions there. Another exception is if an individual demonstrates a direct threat to the health and safety of others, the housing provider would not need to grant that reasonable accommodation request to grant that person housing because of that substantiated threat to the health and safety of others on the premises. All right, so if you are seeking housing or you're assisting someone that's seeking housing and you believe that a housing provider has not complied with these guidelines, has denied a reasonable accommodation request, or has used disparate treatment or has a policy that has disparate impact that would violate our fair housing laws, you can file a complaint with PHRC. And I want to provide our contact information here. You can see our 3 regional offices that I mentioned earlier on the presentation. Their addresses are there, their phone numbers are there. That's ways that you can get in contact with us. You can also email us at phrc@pa.gov, or you can go on our website there, or even find us on social media to get additional information. There are lots of ways to get in touch with us, but please reach out. And I want to share a little bit about that process. So it starts with intake. So if someone believes that they've experienced discrimination, their first step is to connect with our intake team. They're going to be asked to fill out a housing questionnaire to provide contact information. They'll be asked to share about what they experienced and the person or the organization or the company that they're filing a complaint against. So the person that files a complaint, they're called the complainant. And the person who has a complaint filed against them, they're called the respondent. So the intake team assesses their information to see if this is a situation that our agency can investigate under our state law. So if that complaint is jurisdictional and if it's timely, the intake team will work with the complainant to finalize that complaint, and then both parties are notified. And then it advances to investigation. So both parties will provide information to a neutral investigator who's responsible for investigating if there's a violation of our state law. So I want to emphasize this. Our investigators do not work on behalf of complainants, and they don't work on behalf of respondents in the investigative process. They are completely neutral, and their role is simply to see what happened and is this a violation of our law. And they'll do that by asking for documents, interviewing witnesses. They may hold a fact-finding hearing or seek other ways of obtaining evidence. They might go on site to a property to investigate. We do have mediation services at PHRC, and that may be an option depending on the case. And both parties would need to agree to mediation in order for that to move forward. But an investigator will also explore if it's possible to settle a case before a finding. All right. If we do proceed to a finding, there's two potential outcomes. There's probable cause, which means that there is enough evidence to establish that discrimination occurred, and no probable cause means that there was not enough evidence to determine that discrimination occurred. If no probable cause is found, that's basically where this complaint ends. It can be appealed, but other than that, it would be closed out. If probable cause is found, then the case may move on to conciliation, advance to a public hearing, or be filed in court. So at this point, our goal is to seek remedy for this discrimination that occurred. So we're no longer neutral as an agency. And there are often questions about how long does it take to investigate a case? And that really depends. I can't give you a specific time frame. It's really based on the evidence, how speedily both parties respond, as well as other factors. So unfortunately, I can't give you a specific answer to that. What are potential remedies that can be sought through this process? Why would someone actually file this? What can they accomplish through this? They can get a reasonable accommodation or modification that's needed, with the impact of being that that someone's able to get their disability-related housing needs met. They may achieve a change to the lease or policies to make sure that both that tenant as well as other tenants of that housing provider are able to have fair policies that are not discriminatory. There may be a posting of fair housing notices, so that way everyone's fully aware of their rights and responsibilities, as well as training for the respondents. So that way they are fully aware of our fair housing laws and their responsibilities, and hopefully don't run into issues again in the future. There may be a reimbursement of fees and out-of-pocket expenses associated with the complaint, as well as it could be fees that were charged that shouldn't have been charged throughout the tenancy. In addition, in housing cases at PHRC, there can also be money for humiliation and embarrassment. This is unique to housing and commercial property cases. You won't find that in terms of our education, public accommodation, or employment cases. And we recently finalized some guidance that you can find on our website that explains a little bit more about how we look at humiliation, embarrassment, and make those calculations. And lastly, there may be civil penalties that are assessed if it moves on to public hearing. It can be up to $10,000 per count on a case, so it can be very expensive to violate our state law. And you can see that from some of our recent housing awards. Anywhere from $1.5 million, a housing provider who failed to provide accessible units and ignored requests for reasonable accommodations for tenants with disabilities, $100,000. This was a case in which a maintenance worker sexually harassed a female tenant. $90,000, a housing provider actually revoked a lease and failed to address neighbor harassment that was based on race. And $77,000 award in which a housing provider made discriminatory statements and refuse to rent to a household based on familial status. All right, we're getting towards the end, so I want to just wrap up with some best practices. So for potential tenants, be honest regarding your record. Most housing providers are going to run a search, so it's good to not share untruthful information about what's in your past, but to share that in a forthright manner. Know what your rights are in terms of fair housing and your rights against discriminatory practices that can use criminal records in an adverse manner against you. If you do need a reasonable accommodation because of your disability, please make that request. We encourage you to make it in writing, but you can make it verbally as well. And if you believe that you've received a wrongful adverse action, contact your housing provider for more information about their process, why they made that decision, and see if they are willing to engage with you to do a case-by-case assessment. We do have a fair housing line, and I encourage you to reach out if you've got questions. That number is 855-866-5718. I want to reiterate that you do have the right to file a complaint if you believe that you've experienced housing discrimination. And I want to make sure that everyone is familiar with that process as well. For a housing provider, consider using other screening criteria. There's other effective ways to look at someone's viability as a tenant instead of criminal history. But if you do choose to use a background screening, make sure that you've got a written policy that's available to all of your applicants, and make sure that that policy is based on reliable evidence, not just assumptions about someone's background. Ensure that your policy considers the nature, severity, and recency of criminal conduct, and be cautious when you're using third-party screening companies. You want to make sure that you're avoiding the use of third-party screening companies that are using algorithms that may have racial or other prohibited bias in their design. And these have not been shown to reliably predict risk. They may produce inaccurate information about the person who's applying. And these companies sometimes make a decision for the housing provider. They just provide a flat recommendation on how to proceed rather than providing the information to the housing provider to make their own decision in this case. It's really important to use good judgment when you're using a screening company. You want to make sure that you give a prospective tenant the opportunity to correct any inaccurate information or explain mitigating circumstances before making that action. And consider delaying consideration of criminal history until after all of the screening criteria have been applied. And when you do conduct individualized assessment regarding criminal histories, make sure that you're doing that in clearly defined situations using staff who have training to avoid bias. And you can see the source for these recommendations. They come from the U.S. Department of Housing and Urban Development. They did some 2022 guidance on this for housing providers. And you can see the link to that also in on this slide here. That's the second resource. There's also a 2016 guidance, as well as a resource for National Fair Housing Training is the National Fair Housing Training Academy. They have monthly forums, and I provided a link to a past one that is the strategies for addressing discrimination, housing providers' use of criminal history, and you can view the recording and access the materials for there. It's completely free and a great resource for you as well. But we have some state fair housing resources as well. I mentioned our fair housing line. We also offer these monthly trainings as well as custom fair housing trainings and consultations that we can provide to your team or to your organization or collaborative. Whoever's interested, we are happy to come out, do it in person, offer it virtually, because we want to make sure that this fair housing information gets out into communities. We've got written resources such as brochures and fact sheets. And we also have a program on PCN TV, which is called PHRC Speaks Fair Housing in the 21st Century. And you can access all of those recordings on our YouTube channel if you're looking for some more in-depth conversations around fair housing issues. But I've got contact information here for you. You've got my email, you've got our fair housing line, and you also will be seeing a QR code on your screen. So I believe Director Eister will be popping in the chat a link, so that way you can access that by link. But if the QR code is better for you, please use that. It's a quick survey, and something new that we're trying out this month is to allow you to be able to download a certificate that that certifies that you've taken this training. You'll be able to fill in your name and download that as a PDF and have that for your records. So that way you can demonstrate that you've taken this training and have undergone that professional development. Okay, now I know there's a bunch of questions in the chat, and I also saw that there was a request to go back to the contact information slide. So I'm going to go back to that contact information slide. And I'm going to go into the chat to catch up on some of these questions. I see we've got about 10 minutes. There's a question, how do we access reasonable accommodation training that you mentioned earlier? Please email me. I'm happy to set up a training for you. Or if you'd like to access the pre-recorded training, we do have Fair Housing and Power Hour trainings on reasonable accommodations that are accessible on our YouTube page. And you can access that YouTube page, I believe, from our website, or maybe Director Eister would be able to locate that and pop that in the chat. I'm going to go back through. Will we receive a copy of this PowerPoint training? Yes, absolutely. I'm going to send that out along with the recording, so that way you have all of these live links and all of this information. All right, I see a couple of questions about reasonable accommodations and when to disclose a disability and when a housing provider needs to accommodate. And the answer is a housing provider needs to accommodate at any point in the tenancy. So it could be at that first inquiry about a unit, could be at the lease signing, could be at move-in, could be 10 years after someone's lived there, or even right before someone's being evicted. It doesn't matter. That request is valid at any point in the tenancy because people's disability-related needs change. So it is up to the tenant on when they're going to disclose their disability-related information and make that request. Simply from a relationship building perspective, it can be helpful to be upfront about information to establish that relationship with a housing provider. But again, an individual with a disability does have the right to make that request at any point in time. Some examples of predatory lending could be offering poor rates and conditions for a loan to someone on the basis of their protected class. It can also be avoiding providing lending services to individuals based on the demographics of the neighborhood. There was a big case a year or so back with Trident Mortgage Company where there was a $22 million settlement based on the way that company provided their loans. So where they located their lending offices and stationed their mortgage professionals, how they conducted their internal communication between their employees, as well as the way they did their advertising. They weren't providing equal services to individuals based on their race and their national origin. You can find some more information if you Google that as well, or I can also send you the link. Let's see. I see some more questions about the slides, and I apologize for all of those technical difficulties. That phone number that I see there, that 866 number, I'm not sure that goes to our office. There are fair housing agencies throughout the state, private nonprofit agencies that receive federal funding. There's also separate enforcement agencies in local areas throughout the state, so that number may go to one of them. I encourage you to reach out to PHRC using the numbers on the screen here, to the regional offices, to our main number, or using our fair housing line to reach us. I see a question about whether reasonable accommodations apply to credit issues in addition to criminal background checks. Absolutely, that's a great question. Individuals with disabilities may often have issues with their credit based on their disability. And they may have low credit, but the ability to be able to afford a unit, to have stable income, even if they've had issues in their past. So I would definitely recommend making that reasonable accommodation request if they believe that the issues on their credit are related to their disability, and that it's a reasonable request to request that change. All right, I see a question. Whose responsibility is it to pay for a modification? If the landlord is private, but the tenant is in a housing assistance program funded by HUD. So if it's Section 8 or Housing Choice Voucher Program, then it would be the tenant's responsibility because the tenant could choose a different unit with different accessibility features and be able to access that housing without necessarily making that modification. But if it's a project-based voucher, I believe, then it would be the housing provider's responsibility to pay for the modification. And if you have further questions, feel free to reach out to me via email as well. All right, and I'm seeing one last question. No credit versus bad credit. Does it matter or make a difference? In terms of fair housing and making a reasonable accommodation request, you would simply want to make that connection via the person's disability and their disability-related needs and that credit score issue. But in terms of a housing provider being able to screen a tenant and how they consider that, that's going to be on a case-by-case basis based on that tenant or based on that housing provider's their screening criteria. And I do recognize that credit scores can be an additional barrier for folks who are returning from incarceration with a background as well as a poor credit score. That can be incredibly difficult to be able to find a housing provider who will deal with both of those issues in their screening criteria and accept that individual into housing. Thank you, Director Eister, for putting that training program's flyer in the chat. I believe if you click on that, you'll be able to actually access that in a readable format. And please feel free to check out PHRC's Fair Housing and other training programs. We've got a lot of different offerings that I encourage you to take a look at because they are free and they are resources for everyone in Pennsylvania. I believe I got to all the questions in the chat. If I missed yours, I sincerely apologize. Please feel free to pop that in the chat or raise your hand because we do still have 2 more minutes. I would like to thank you all for all of your great questions, all of your great interaction, your patience through our technical difficulties today. And I'd like to take a moment to thank our ASL interpreters and our captioner as well for their services today in making this program accessible. Thanks to Director Eister for her technical assistance on this program. And thank you all for your time today. I hope you enjoy the rest of your day. All right, I am not seeing any additional questions in the chat. So at this point, I'm going to close out the program, and I do want to let you know that we will be sharing both the recording as well as the materials from this presentation to everyone who registered. So you can catch up on anything that you missed and take a look at some of the links and resources that are in these slides. Thank you all. Have a great day.